advocate. I am the lip for we music and we culture. You see that particular song? Plenty devils out there, boy. You feel it jab jab.
I hope the powers that be PM and so on doesn't think that
Yeah.
you're throwing any big stone in the dark and hoping he responds.
Well, let's see who the cap fits, let them wear it. If the cap should the PM, who is me? I'm a little small time, you know. The PM could get rid of me with a snap of a finger. I have to play a calypso, and if it falls in his garden, well.
Remember some years ago, a policeman responded to Dr. Manning, him and Dr. Manning, Patrick Manning.
Yeah.
The what was carrying the editorial is he responded to the Prime Minister and said, well, what the commissioner would do, pull off my pants and beat me. And then legend had it that the policeman he no longer held office. I think it was an SRP.
Who's I get an SRP? Well, no. Where that is concerned, he'll beg for that. You know, I'm a normal citizen. I'm a member of the media fraternity. I have some rights, you know, partner.
I could potentially in that case before the court.
Yeah. I will.
Industrial court.
Yeah, I am a big time lawyer like you. I don't feeling at all. We going on with big millions too. These days, when you're dealing at that level, it starts from 10, 13 million. So that's the kind of pay. I would like to be in that zone. Jeez. I'll finish my project. My grands and my generations to follow will be happy like papi. I tell you.
Where's Richard today? He's
joining us very short. You know, Richard, he comes in a bit. You know, he's have to get himself together. He's a busy guy, you know. Yeah, he has a lot of caps to wear. Yeah. So when he takes off the first 10, he'll come to this one in a short while. But so much things to say, according to Bob Marley, boy. So much things to say.
Maybe we could chat a little bit about this situation with the former Attorney General and Mr. Ramdeen. What I find, and let me talk about it from a lay perspective, right? Let me introduce no law into the dialogue yet.
No.
I found it strange, right? I found it, and I'm using the word strange to be as lay as possible in terms of simple language. Mm-hmm. This news broke about the DPP's decision to discontinue the case against both gentlemen, Mr. Ramdeen and Mr. Amlugan. Mm-hmm. And the decision to discontinue the matter, that decision, in my experience, could not have been made in 5 minutes. That decision would have been subject and conditioned by certain forces. Simply put, Mr. Nelson, his position would simply be that he was not willing to offer evidence again. They would not have found that out on the morning that the information was released. Yeah. So maybe, you know, in order not to preempt the eventuality in the court, meaning you can't release something into the public space and it hasn't been proffered and offered before the court, meaning the court was not informed first. Yeah. So I could understand that sequence from a legal point of view. Mm-hmm. But all of this had to been brewing for weeks and possibly months before they decided that consideration was given and the decision was made at the DPP's level to discontinue. So it puts us in a position where for people like yourself and me and the public listening out there, so many things are happening quietly and silently as it pertains to public interest. And, you know, we are the public is the last recipient of the information. What I find strange, and allow me to put it this way, I find that the usual songboards and song bites that comes from the specific ministers in the government, and I'm willing to say Mr. Hines, etc., they're not saying anything about this. They're not, to me, I'm not hearing any big interest group kicking a fuss. This decision seems to be accepted and taken in stride. It wasn't like, you know, normal noise and foray that goes with public uproar over a situation.
Yeah.
All the same, I just find it, I don't want to say disturbing, I just find it strange that so many coincidences came together. The discharge of the individuals, the decision by Nelson, which should have been preceded by Nelson refusing to offer any further evidence. The DPP made it very clear that he cannot extradite the witness. This is not one of those cases that you can, because the extradition can't deal with, it doesn't speak to a witness being brought back into a country. The witness has committed no crime as such, because a consent order was offered. He entered into a plea agreement where, in exchange for immunity, he was offering evidence. The immunity has already been granted. So we are the second phase where he was going to offer the evidence. So when he refuses at this stage to offer the evidence, you can't turn around now and withdraw the immunity from prosecution. You follow?
Yeah.
So it's almost, I don't want to say Mr. Nelson in Trini language outsmart them, but it makes one wonder that he was given, he pled guilty. He was put on a 3-year ban, a 3-year bond, right? So placed on a bond to keep the peace for 3 years. Immunity was offered, he accepted, he pled guilty, it was extended to him. There were conditions attached to the second element, and the condition was that he offers evidence against Ram Logan and Ram Dean. So it means to say that the horse went before the cart, right? He pled guilty, he was placed on the bond for 3 years, the immunity applied to him, and the second phase is he's going to offer the evidence. If it is at the end of the day, there's a condition attached to him offering the evidence, which is indemnity, right? It means that what was supposed to be done at this next stage would have been for the state to fulfill certain promises to him, Mr. Nelson. And those promises, if they're not fulfilled, then he's not required to offer the evidence, because the evidence was being offered in exchange for indemnity. And there was a criteria in which that was supposed to be so, which is they're not going to offer, they're not going to make public certain information about him. I guess the details as to all the facts surrounding him offering a kickback and so on. We could talk boldly like that with regard to him, because that is indeed what he said, that how he was offered a kickback, and he that was part of his arrangement. If it is the state didn't honor the condition that they were not going to reveal all the particulars surrounding what he pled guilty to, it was not going to be used in the public space and so on, and then that was done, they reneged on that, then the state forfeit the right to pursue him with regard to any evidence to offer against the individuals. It means to say, had they put their house in order, we may not be in this position now. And I say we, meaning the public. The public would be in a position where, there could be some sort of resolution before the court on this point, in terms of the conspiracy between Ram Dean or the alleged conspiracy between Ram Dean and Ram Logan, and whether they were complicit in anything, in any way to defraud the state. Now that comes to rest. What does it mean? The issue is now, what does it mean for Ram Logan and Ram Dean? It simply means that they can return to a public life. There is no longer any issue standing over their heads. The court is the ultimate arbiter of fact and law. The DPP has chosen to withdraw the case against them. There are means by which, in law, David, where if it is a witness is unable to offer evidence, once they give a signed statement, then the signed statement could be admitted into evidence, and that could be used against the accused. The disadvantage is, if that procedure is engaged, the defense attorneys for Messrs. Ram Dean and Ram Logan those attorneys would be deprived of the opportunity to cross-examine the witness and verify the truthfulness of what is being said, or challenge the truthfulness of what is being said. And he would not be able to stand before the court by not offering himself for the judge to make a decision or make a determination based on his demeanor as to whether any veracity could be assigned to what he's saying. Let me put it in different language. When a man goes into the box and he swears on the Holy Bible, he affirms that he's going to tell the truth. The eyes of the court are upon him. The judge is looking at him. The prisoners sitting in the dock are looking at him. The courtroom atmosphere, he's part of that courtroom atmosphere. And the pressure that one would feel there, the judge is going to look at his demeanor. It's like you caught your grandson doing something he shouldn't be doing. And based on his body language and his facial expression, you as the grandfather would be able to, knowing him, or you would, or maybe you don't even know him on that level, but you'll be able to judge from his body reaction, his facial responses, that he culpable, he's doing something wrong, or he's saying something wrong, or he's lying. The purpose of having a witness in a courtroom is for you to be able, you as the judge and the jury, to be able to look at the witness and make a determination when they're speaking, whether this person is a person speaking from a position of truth. So if you start to stutter and stumble, and this is how to eat up your words, then they would say, he ain't answering the question with the sort of precision that you would expect of a witness who's coming to say the truth. So our position is we've been deprived of that. We've been deprived of having Mr. Nelson offer his evidence and the court being able to judge the witness and to assign credibility to what is being said, and to assign value to what is being said, and being able to make a determination. It means to say now that this matter has gotten to its wit's end, to a dead end. The withdrawal means that it's complete and it's finished. So I think Mr. Ram Logan may just have one other matter that he has to answer to. And that is of a different nature. It doesn't touch and concern this alleged kickback. Well, what do you think about something like this? Do you think that you would have liked to see this thing go the distance?
Well, yeah, I mean, the big hullabaloo that brought it into prominence back then, and I don't know. Sometimes I think that these guys know what they're doing. They know it would have reached to this state, and then that's it. Elections are in the air, and I think it's designed to confuse the layman like me, right, and have us wondering what's going on while these guys are in. Because I'm seeing on the newspaper today where Mr. Nelson will be suing the state for $100 million and that kind of thing. So I don't know. I would have liked to see that gone its way, and some sort of judgment or some of finality we could have reached to. But now everything is dropped. People are wondering what's going on. We're hearing about millions and millions and millions and millions, and everything just fell flat. So what happened to all those millions and millions? And where are they getting those millions and millions to pay out if Mr. Nelson should take some sort of action? I think, all in all, the people on the ground are the ones who are suffering all the time, whether this goes through or not. I mean, that's a serious issue. And I know I don't understand it totally, because I wasn't really following from the start. I just heard this and heard that and heard the other, and I was saying, okay, these big men are indulging in this kind of thing, and well, it had gone to the court. It couldn't be prejudicial to say anything while you're on air and all of that. Right. So I was just hoping that something happened. Then out of the blues, we're hearing that the matter was dropped by the DPP. We are hearing Faris saying this and Faris saying that, the opposition leader saying this and the opposition saying that, the new AG saying this and he's saying that, and just confusing the people like a distraction to all the pressures that they are already going through. So I would like this to be a discussion today when Richard comes on, to let people understand a little more, because I'm not good at law at all. I don't know what's right and what's wrong and what you're jail for.
Let me put it this way. According to the Newsday article written by Jada Latu, right? It did say that Mr. Nelson entered into an indemnity arrangement with Faris Alwari in October of 2017.
That should be explained.
Right. The indemnity arrangement simply focused on, and I'm quoting here, there were also certain promises made which included not making any disclosure of the information to any criminal investigator, also not making disclosure of any information to any prosecuting authority, also not making any disclosure of information pertaining to tax enforcement authority or disciplinary authority outside of Trinidad and Tobago. So, in other words, what basically the article is saying, and this is what we got out of the agreement that was signed between Faris Alwari and Nelson, is that demands all the particulars surrounding this allegation, right? And it was more than an allegation because he pled guilty. He got an opportunity to plead. He pled guilty on the basis of they're going to be offering him immunity, right? So, and the particulars of what he pled guilty to was not supposed to be made public, which is anything pertaining to any information that would be made available to criminal investigators, for prosecuting authority, for tax enforcement authority, and for any disciplinary authority outside of Trinidad and Tobago. So basically, what they're saying is there were confidential things surrounding the facts of the matter that the Queen's Counsel didn't want in the public space, and they did not honor that. So he's suing them on the basis of, you made all this information contrary to our agreement available in the public space. And he brought them before the court, and there's a civil suit in relation to that, for breaching that. Now, my thing is, if it is the agreement was that it was not supposed to make all this information available to the public, information as it pertains to these things, then why didn't the extra step be taken, the extra precautionary step taken to ensure that the conditions of the indemnity were honored? And now that you didn't honor it, the cost is going to be borne on the taxpayers' back, because the state will have to pay if this gentleman is successful at his suit, in the civil suit. Now, this arrangement was entered into in October 2017. They said it was subsequently initialed by both men, meaning Alwari and Nelson, in 2019. So I guess subsequently initial mean that they reinforced and they reiterated their positions with regard to each other from as far back as 2019. So the public wasn't made aware as to the conditions attached to it, nor should the public be made aware, because if this is an arrangement in terms of a court procedure, what happens in the courtroom stays in the courtroom. The only thing that will be made public is the final result, which is the sentencing. There are things that you don't carry in the public space, which I guess is when Nelson had us. He simply said that, I'm going to enter this agreement. Part of the agreement is to remain quiet about certain things. So, well, maybe we could stress something else. You remember in the 80s when a lot of witnesses were dying in the 1980s? They said there was a phenomenon in this country that witnesses kept disappearing. They were killed, and then when the evidence couldn't be offered in the courtroom, the matter fell by the wayside, as we would say.
Yeah.
Right. What happened in order to counter things like that, witnesses being killed, and therefore the case collapsing as a result of the death of a witness? Certain amendments in law were made as it relates to evidence and the admissibility of evidence in the courtroom. So there were amendments made to the Evidence Amendment Act, which catered for, under what we call Section 15C of the Evidence Amendment Act, 2009. It allowed for witnesses who were dead, their written statements that they would have signed before they met their demise, to be admitted into evidence and be used in a courtroom. The advantage used to be that when the witness is there, the case, there's nobody to offer evidence, and the case collapses. What they will do now is, when the person is dead, the statement having been certified and sworn to before a JP and served on the and filed in the courtroom and served upon the defense, that statement can now go into evidence, and as a result of the death of the individual, the case doesn't fall. The statement moves forward and the evidence moves forward. The disadvantage the accused finds himself in is there is nobody for his lawyer to cross-examine, or his lawyer to simply cross-examine along the lines of destroying his credibility or showing that, making him out to be a liar. So the accused person found himself in a difficulty where if it is he was responsible for the death of the witness, he now places himself in the difficult position of not having the advantage of being able to question the integrity of the witness and the credibility of the witness and test the truth of what he has to say. So it works to your disadvantage if the witness dies. You have an interest in ensuring that the witness survives. Similarly, when it is a witness is fearful for one's life and the witness doesn't want to come to court to give evidence, you could make what we call a fear application, and the statement signed by the witness, sworn before JP, declared to be truth. That statement goes into evidence, and the prosecution makes an application to have the statement admitted into evidence and the witness not be offered for cross-examination. Or if he is offered, there are certain mechanisms put in place to ensure his security of person and property. So there's law for that. So my thing is, if Nelson's issue was an issue of his evidence could be offered in a different way, then that could have reasonably happened. The problem was they entered, Richard, the problem is with him, is the man entered an indemnity order. He entered an agreement under the Plea Bargaining Act. And part of the agreement is he laid out his terms and conditions. I'm willing to offer evidence, but I'm willing to offer evidence if you all meet certain conditions. So he pled guilty. He was offered the immunity. And then the second phase of it would have been he offered the evidence before the court on the condition that the indemnity, right, on the precursor that the indemnity would have been honored. So when it is he pled guilty and was placed on the bond for 3 years to keep the peace, that has been achieved. He secured himself. The other condition was, as long as you honor the terms of this indemnity, meaning that the immunity you offered me, the terms are that you're not going to speak about certain things, make any information available to criminal investigators, make any information available to any disciplinary body outside of Trinidad and Tobago. Once you don't do those things, then I will then offer evidence against these two men. And it seems that what he brought the civil suit against the state for is that the state didn't honor that. Now, if the state had an interest in ensuring that we secure his evidence and the availability of him to offer evidence against Ram Logan and Ramdeen, the state should have taken all reasonable steps to ensure that they don't breach the indemnity arrangement they entered with the man, with Mr. Nelson. I don't know. It will be interesting to find out when the civil suit run its course, what the findings of the court are, because he is now suing and saying that you didn't honor the terms of the indemnity, and therefore my information is now out there. Bear in mind that he's still a practicing attorney, still practicing before others' jurisdictions. He's a Queen's Counsel. So when his information now and the information surrounding what he pled guilty to finds itself in the hands of a disciplinary authority outside of Trinidad and Tobago, action could be taken against him. His reputation could be affected, because one of the conditions of him pleading guilty was, we are not going to talk or discuss anything, or certain information is not going to be made available in the public space. So let us say there was an issue of him receiving a kickback. That is not information to be proffered and offered elsewhere outside of Trinidad and Tobago. If an investigator was trying to get behind the walls of what exactly happened in Trinidad and what involvement he had, the DPP was not going to make any evidence available. The police complainants and the investigative team that put together that evidence was not going to hand it over to anybody else to be used for any purpose outside of Trinidad and Tobago. So that not having been honored, the man say, all right, so the agreement collapsed. I'm not offering no evidence because my evidence was being offered on that condition. So somebody has to answer now, or if anybody at all. I would like to think that the DPP did the honorable thing, Richard. The DPP has a function to prosecute matters against persons charged before the court. And the DPP is not the villain here, and nor am I calling anybody villain, but I'm for want of a better expression. The DPP didn't withdraw this because it felt like it, or the DPP's office didn't choose to withdraw this because, they had enough, the board. There were legal reasons why, and Mr. Gaspard specifically came out and said that without the evidence of Mr. Nelson, then we cannot prosecute these individuals. And if it is the evidence collapses, if there is no more evidence available, then the DPP did the correct thing in indicating at the earliest possible opportunity that we cannot offer evidence, and that having been satisfied that there's nothing we can do, we could only withdraw the case against the individuals. So their hand has been, the envelope was pushed because they were being pushed, and they did what they had to do.
So in the absence, you hear me?
Richard, check your volume.
Yeah, your volume is very low again.
Go ahead. You go ahead. Let me check this again. Something had to be wrong.
Richard, your volume, we're not hearing you at all.
Farid, you can continue, Farid. He'll join us. He'll rejoin us in a while.
Nice. Yeah, so David, it's you know, this is what, when things like this happen, right? And I'm referring things like this purely in the context of the arrangement with Mr. Nelson wasn't honored, and therefore the DPP's hands being forced to withdraw the case against the individuals. Where does that leave the layperson? The laypersons become very frustrated with the justice system. It undermines people's confidence in what is just and fair and reasonable.
Yeah.
Persons who are hearing this, the man who traveled in the Maxi, the layperson in the street who working in URP and in CPEP, the simple people who don't have this sort of specialized training in the law, their mindset will be, boy, look at a big boy just get away again, boy.
Yeah.
Or the mindset might be, you know, when you're on a certain level in this country,
Yes.
vis-a-vis white collar crime, that persons who are in this elite bracket, who have the power to operate on a certain level, that they don't face the same licks that the man on the floor takes.
Exactly.
And that is not a good sign. So when it is we see that public trust and confidence is not what it should be, meaning that the public don't feel that, you know, we could really get anything out of this society. It's understandable. It's understandable, and it's sad that this matter couldn't go the distance, because had it been determined even in Ramdean and Ram Logan's favor at the end of a trial process, at least it would have been accepted.
I don't know, no, Farid. Farid, you know, sometimes they say it's a bush lawyer, and you know them lawyers who will stand by the side of the court waiting to go and say, I stand for this fella here or this woman here, and they just got small. You see that level of the guys with the legal minds?
Yeah.
I think they know everything that could have happened based on these slight, you know, intricacies that could trigger off a shutting down or a collapsing of the case. To me, like, they know that, and they just like, if it's a game they're playing, you know, with public funds, you don't understand what's going on. You know, at that level, Farid, these guys at the level of Attorney General, Queen's Counsel, King's Counsel, all kind of counsel, you know, and to know that these guys, it will happen. Yesterday we were taking calls, and one of the guys was saying, one of the callers was saying that he heard from a high-ranking political person
Yeah.
that this would have happened. How could that be? How could that be? You know, it seems as though, well, I don't know, maybe the money that we are making from Ukraine is coming in barrels and tankfuls, so much so that they don't know what to do with it, and they decide to share and leave us out. They keep telling us things are hard, but when these instances come about, you hear about 13 million, 100 million for like one person, you know?
Yeah.
The kind of briefs and the cost of these briefs, or the money that it takes for these lawyers to have these briefs, I mean, G's and ages.
Well, I know what
This
you
would have never happened in other countries. All now the city might have been in ashes. Nothing. It's only Trinidad this thing happens, and it seems as though these guys know that. They know they can play up with the law and do all kind of things. These guys are the hierarchy of the legal minds, you know.
Yeah.
They must know the loopholes and how they can get away and how they could twist this and twist that. If you say the indemnity said, okay, nothing here should be leaked, and that if done, this will happen. It was, and this is happening now. Small men like me and other people on the ground are baffled over this thing. While we catching aunt, nan, and uncle, all kind of thing to put food on the table, to carry children to school, so to get a little more than 4% or whatever. Look at what is going on at the top there. And it's a battle of this ex-AG and AG, and this big lawyer and that big lawyer. What really going on in Trinidad here? What's really going on? It's difficult to swallow, trust me. And it's very puzzling because I wasn't too taken up on that, and I just know they have these guys facing these criminal charges or whatever kind of charges they call them, and they have to face the court and this, and out of the blues, this happens. Men walk free, everybody has something to say, and nobody will ever make a jail or made to pay. That is what bothers me.
And the nature of the charges, this is not a cost case. It's not a cost case, as we would say in lay language. It is not a summary offense.
No.
Both individuals were before the court on charges conspiring to engage in money laundering, corruption, and misbehavior in public office.
I tell you, that's not a small case, no. Joint marijuana case. That's at the highest of all levels to get to the bottom of something that was, I don't know, at the highest level of corruption. We have even the Prime Minister and all coming in and putting 2 cents to it, and we down here now, we just hoping that, well, at least one of them could make a jail, boy, this kind of thing. These men, boy, they're thieving all the money, they're doing this, they're doing that, and nothing happens. I won't be surprised to see after a couple of days, we're not hearing anything about this again. It happens in Trinidad all the time.
David, we began by me saying that I find strangely that you're not hearing any big sound,
no,
and noise bite coming from even certain members in the sitting government. Normally, they're the usual suspects, the people who go in and kick a big fuss and say a lot.
Yeah.
And everybody on both sides are very, very quiet.
Yes.
The Attorney General's office released a statement, and nobody's saying anything except me, you and I making more noise about this than everybody is.
Yeah. So what? I don't know. I really don't know, boy. On top of all of that, listen, Farid, I'm a man on the ground all day. Farid, I am fed up hearing the cries of the people. I'm fed up hearing about who catching this and who going through this and who, like, everything is just like people moving around like robots now. And all of this is happening. We're not hearing anything that is what should I say, that will put some sort of sanity to the thing so that we can understand. It's a sort of high language and indemnity this and that and the other. And this guy, like you said, he could have pulled a fast one of them, or they probably set up the whole thing. Some people are saying that, they say, see them fellas know what they're doing, but this country are real money, they're just not sharing it with us.
Yeah.
But they having a time at the top. There's millions and millions, and all of them are friends.
Yeah. Well, they say that politicians are friends with politicians, and politicians aren't friends with people on the ground.
No.
And in politics, they're permanent. There are no permanent friendships. They are permanent alliances.
Yeah.
You align yourself to somebody, albeit for the convenience of achieving objectives, not necessarily nefarious objectives, but a man will cross the floor and join a political party, join the opposing party in the morning.
Yeah.
And we could see examples happening right now.
Yeah.
And happened through the years. It means to say his allegiance wasn't so much to the ideology and the philosophy of the party that he was representing. His allegiance was to personal interests or some interest that he hasn't declared. So hence he could switch parties.
Yeah.
So the saying that in politics there are no permanent friendships, there are permanent alliances. It means to say that a man will turn his back on his friend if it is means aligning with the other side to suit a particular and peculiar interest.
That's right. That's right.
So politicians, people, when the politicians parade in parliament and they perform in parliament first, we shouldn't take it personal, because don't doubt it, if the two men who just put on that fiasco and ball at each other, they're probably going home in the same car after working.
Yeah, I'll meet you by some of these fancy bars and we sit and take a drink and knock glass and say, boy.
What about the tea room downstairs?
Oh.
I want that in the tea room downstairs.
Yeah.
All are equal, you know. It's only government and opposition when you get into the house upstairs. But when you exit and everybody reach downstairs in the tea room, they deal with each other on the same level.
I think that happens only in Trinidad, you know. I mean, I've seen real big timers in coveralls and chains on their feet in America and thing, you know. Oh, these fellas here know that. They know how they design the Constitution, which is supreme law, and they leave out a lot of spaces so they can walk and have a time. I don't know. Yeah.
But let me allude to something. There's what we call the Proceeds of Crime Act in Trinidad. I want to read a small portion of it. The offenses that these individuals were charged under was under the Proceeds of Crime Act. Section 44(1). It reads, an offense committed under Section 45 shall be known as a money laundering offense, and the term money laundering shall be construed accordingly. So it's talking about, remember, it's money laundering and corruption charges that these individuals will be before the court for. So they're going on to explain what they consider to be money laundering.
Yeah.
Because we hear the word money laundering in the public space, and all we think is, we're thinking theft, right? We're thinking you have money that is not your money. From a lay perspective, you have money that was derived from ill-gotten gains. Let us say something criminal, and the money is now in your possession. It wasn't money that you worked hard for. It wasn't money that you duly got. It came into your hands by fraudulent means and so on. It goes on to say the offense of money laundering is an indictable offense, meaning it's a serious offense. And Section 45(1) of the Proceeds of Crime Act goes on to describe a person who knows or has reasonable grounds to suspect that the property is criminal property, and who engages directly and indirectly or indirectly in a transaction that involves that criminal property, or he receives, possesses, conceals, disposes of, disguises, transfers, brings into or sends out of Trinidad and Tobago that criminal property, or converts, transfers, or removes from Trinidad and Tobago that criminal property, commits an offense of money laundering. So it involves two things, you know. You must know that the money you got, right? You must have good reason to believe or to suspect that the property is criminal property, meaning that you get money and you know the money ain't clean money. And you get it and you have reasonable grounds to believe that it is not clean money, it's not good money, it's not money that is rightfully and duly gotten, fairfully gotten. It's not the earnings of, not your earnings, or it belongs to a body, a state body or a private body, in this case, a state body. If it is when you got that money, you engage directly or indirectly in a transaction that involves that criminal property, then that in itself is that falls under the ambit of money laundering. Richard, you with us? Let's try the volume.
Well, I tried something, but that it's still in working.
Yeah, it's still very low.
We hearing you better now.
You hear me?
Yeah, man.
Well, you'll have to take down one. Take down the one that says Let's try the iPhone. I think the iPhone is sounding better.
Yeah.
All right.
So what would happen, is that I would see you all from here, but I'll talk on the iPhone. You hear that?
Clearly.
Great. Nice.
It's working.
Okay.
Down on the...
Yeah, I tried to become a computer official just now. I almost dismantle the whole thing. But if they had to score murder fail, but it worked. I try everything. So the only other thing maybe to try another device next time. Yeah. But this one seemed to be having some serious microphone problems. That's what the Prime Minister said the other day. Oh my God, the government had some microphone problems.
Oh Lord.
Well, it's contagious because like it happened to my device now. But on this matter, I listened to Senior Counsel Elder, right?
Yeah.
She was excellent when she was my A-level teacher in law. And from then to now, she has grown and become significantly more excellent, if one could modify that in such a way. And what she's saying, Fareed, is that the Attorney General, she's asking several questions. One of them is, why you paid the witness so much money? And she's saying Faris Alwari has some questions to answer. You heard her?
Yeah. Yeah.
Explain that to us as a practicing courtroom attorney.
The arrangement that was entered to in October of 2017, clearly they had information that, based on the prosecution version of the facts, right, that they had information that persons were receiving state briefs and kickbacks were going to certain individuals in exchange for the dispensing of cake briefs. So you give it to me, I give it to you, quid pro quo. So the position is Mr. Nelson having been discovered, and I would imagine they provided information to him that you're cornered. You were offering kickbacks, or you were being procured, being asked to give something in return to the briefs that you were receiving. He may have found himself in a position where he didn't actually receive and he didn't actually offer the kickback, but the offer was being made to him and he was considering it. So that in itself is offensive. That in itself contravenes the provisions of the legislation under the Procedure Crime Act. Now, having said that, charges were preferred on himself and the other two office holders. And he was offered under the Plea Bargaining Act an opportunity to plead guilty, and in exchange for his plea of guilty, and his agreement to indemnify the state, meaning that to pay back a certain level of money to the state, that he would offer evidence against the two office holders. In other words, in order to successfully prosecute a matter against Ramdeen and Ramlogan, you would need the evidence of this individual, because it's conspiring to defraud. Conspiring to defraud is you and I and David agreeing, listen, there's the plan of action. We're going to do certain things, and we are, three of us are in agreement that we're going to embark on something criminal. So in order to prove conspiracy, you must prove that there's an agreement between the three individuals. In this case, in using our examples, let's not just use the individual names, between David, Richard, and myself. So one of us has to rat. One of us has to go now and say, listen, David approached me and he make a suggestion, he offered me something. I come to you, I say, Richard, here what going on? If it is Richard, David and I enter into this arrangement, I would like you to conceal, dispose of, receive the money, and to act in a certain way in relation to the cash. So you got roped in because you have a specialized function. So in order to successfully prosecute the three of us, what we need is basically and fundamentally one of us to break ranks and to expose the conspiracy by way of the discussions that was proffered between David, myself, and you. And without one of us offering that sort of information, then how are they going to prove conspiracy? Because conspiracy is an agreement to commit a crime. A party who's not part of the agreement cannot speak to what was the arrangement. So in paralleling this information, Nelson clearly had to speak in order to show what is the arrangement between him and the other parties. And if Nelson is saying, I will plead guilty for conspiring to defraud, but I will be offered, once I'm offered immunity, I'm accepting that. And I will, but there are certain conditions, and there are two conditions. The first condition is there's an indemnity arrangement. So when I plead guilty, they place me on a bond to keep the peace. But the plea agreement, right, would have been subject to plea discussion. So let me put it in a different way. I am before the court for a charge. Under the Plea Bargaining Act, Plea Bargaining Agreement Act, there's a method, a scientific method in which we're going to make a determination this matter. The method is the prosecution sits with the defense. The prosecuting lawyer, the DPP's people, and the defense attorney sits on a table and they enter into what we call plea discussions. The plea discussions is the ultimate objective to getting to a plea agreement. And the plea agreement would be subject to things discussed. So if it is what is being offered is we're going to offer you immunity from prosecution. We're not going to prosecute you. We're not going to seek to put you away to convict you. We are entering this plea agreement following the plea discussion that you are going to plead guilty, so you agree to that. We are going to offer you immunity from prosecution and you will be placed on a bond. The bond is for a period from as little as 1 year to as much as 3 years. They put him on the maximum level, which is 3 years. He's on a bond for it. Means to say he has to keep the peace for 3 years. If it is he commits any kind of offense, it could be a cost case. He will be brought back before the court for breaching the laws of Trinidad and Tobago or committing a criminal offense of whatever kind, it being a minor offense self, and then you will now be sentenced in relation to the matter, the substantive matter, which is this big matter. Now, where we are is this. He got his immunity and the indemnity arrangement, the conditions that they agreed on, wasn't honored by the Attorney General. And him having lapsed in that regard, Mr. Alwari or his office, having lapsed, whichever did it, meaning that if anybody from the office of the Attorney General breached, not Mr. Alwari himself, it still falls under the ambit of the Attorney General's office. If it is they didn't honor the indemnity arrangement, it means to say that Mr. Nelson doesn't have to offer evidence against Ram Logan and Ramdi anymore because it was conditioned and part of the agreement that the indemnity must be honored. Now, when the indemnity wasn't honored, he brought a civil suit against the state. What Mr. Gaspard is saying is that I have a function. I'm not going to step into the arena and get involved in what has happened. I have a decision to make as the Director of Public Prosecutions. I have the ability to further the prosecution or to withdraw it. If it is Mr. Nelson has brought a civil suit against the state for not honoring the terms of the indemnity, and that matter has to be determined before the court, Gaspard is saying it could take years for that matter to be litigated before the court. And if it is Nelson is saying he's no longer willing to offer evidence, then the position as it stands is this. The key witness for the prosecution, for the DPP's office, that key witness is not available. So the only decision left in Gaspard's hands is to withdraw the prosecution, discontinue the matter, let the court know what the position is, and withdraw. Now, if it is, other arrangements could be made with Mr. Nelson, and they were to settle, and Nelson decides that he wants to offer evidence now. The charges could be relayed. The DPP could turn around and say, we want to relay the charges, and they can. However, applications will be made before the court from Ram Logan and Ramdeen's position that this is an abuse of process. And you can't now come and want to relay charges. How am I going to get a fair hearing? This matter there's been pre-trial publicity. It's a high-profile issue. It's a highly politicized issue. Politicians were talking about it. So many people were saying things. And I can't get a fair trial in this country now. So if it is they want to relay down the road in a year's time, it is still within the power of the DPP's office to relay. But certain conditions ought to be met, meaning that the issue of fairness and whether it is fair to the individuals to relay a charge and whether any prejudice could be caused to them and whether they could get a fair trial in this country, all that will have to be considered before they relay.
But so they would have quite a strong argument to take that position based on the amount of people who have spoken in this matter and have said all matter and types of things. So that if they would take that turn, and which is as sharp attorneys as they are, and whoever represented them, just as you are saying, naturally that'll be the first turn, and they'll have a whole lot of papers to pull and present to the court, news, all kind of thing, and perhaps even talk shows. You know, so it really would, and justice is about justice, which means that people should be able to go through the process and feel like they were dealt with fairly. And based on the amount of conversation around this now, since it has fallen, it will become a steep climb for it to be successful to relay the charges. It could, as you're saying, but if there's an argument that they could make on the basis of how publicized it became, and the fact that the person is looking to commence civil legal proceedings for some of what he said he was going to do end up in the public domain, which means part of what was supposed to be heard only in the court is already in the public domain. And that in and of itself would be substantial evidential support to say it might be very difficult for us to have now a fair trial in this country. But since this guy has the star witness, as we tend to put them, Nelson. Yeah, since he has indicated now that he's not prepared to give any evidence against these gentlemen. In law, and from the DPP perspective, he has used this term before, did that now make the case become threadbare without his own?
Yes. Without Queen's Counsel, Nelson offering evidence, they can't prove the conspiracy. Remember, this is conspiring to defraud, you know. This is not actual. They don't have any actual evidence of money passing. There was nothing of that kind. This is 2 people or 3 people conspiring to do something. It didn't happen. The substantive issue is conspiring to defraud. It is not a situation where something actually happened, where they could prove that money passed from one body to the next and state briefs passed and so on. How are you going to prove, Richard, that when a state brief was received by one individual, that a kickback was given to another in return? Because I don't imagine the kickback would have come in the form of a check. I mean, if I...
No, it can't come in the form of a check.
Well, exactly.
It can come in the form of a check. There's an invitation to end up before the court.
Well, that's what I'm saying.
Sometime down the road. Yes. I don't know who would want to participate in such an arrangement. So it wouldn't come in the form of a check, Fareed. People would want to deal in different ways. Cash or kind, as they say.
Right.
But certainly not,
So it lends itself to whether, when things like this happen, nobody would be able, it's very difficult to prove unless it passes through an institution, a financial institution. Then you have to account under the money laundering laws. Where this deposit you're making here today, what was the source of this funds? And very often the bank may clearly tell you, we can't receive this money because you haven't been able to satisfy us that you selling loose cigarette and dynamite from a ton of cardboard box at the side of the road come to make a deposit of $30,000. We wouldn't, the bank, we're not accepting this. That's how
But what is strange with those things, what the bank might accept if you say selling pumpkin. Let me not get into that. Because we know people build mansion and thing for selling pumpkin. But I go take cigarettes and
a wholesale crop of produce might be able to carry that kind of value, but smaller.
So perhaps you could say that to the bank. You could say to the bank, you had a crop of pumpkin and this income from it. But what I could say, perhaps there may be a good argument. They only talking about what was in the public domain and that type of thing. But tell us about this, Fareed. Explain the part that is out there too about, the Attorney General, former Attorney General, possibly offering, that's in the public domain, gifts to Mr. Nelson to do what he said he was going to do.
Well, let's not use the word gifts. The word that is in the public space is indemnity. The thing with the indemnity is, we have to get back to this plea agreement situation. The Plea Bargaining and Agreement Act 2016, it would have predated a substantive piece of legislation. There were amendments that were made to it. What the act allows is, rather than an individual engage the processes of the courts and have to enter a plea of guilty, or let us put it another way. There's a case against you. The police have gathered evidence. There are statements signed by individuals, certified with their signature. There are declarations made by the individuals that this is the truth, this is what happened. There is evidence against you. So there may be exhibits. Let us say possession of marijuana, a common offense out there. So the police investigator would have gotten information. He would have conducted an investigation. He would have found plant-like material resembling that of marijuana on your premises. He would have offered a statement and said, this is what I found. I executed a warrant. The warrant was in the name of Farid Ali. I perused the premises, found this item. I found an L-shaped object resembling that of a firearm also. Statement, I would have been taken to station, questioned. I may have confessed, I may not have confessed. If I did confess, they have interview notes. I certify the interview notes by having signed. When I get to court now, they would have had witness evidence where they perhaps interview a relative who say they know that I'm dealing in something nefarious, something criminal. So they use that statement against them. So before you know it, you come to court now with 25 statements. Some of them police statements, let's say 10, 15 civilian statements. So you end up with 25 statements. The process would be that evidence now would be offered in the courtroom, and my defense attorney will cross-examine and try to undermine the state's case. That process could take months. A man sits in the jail waiting 2 years for a preliminary inquiry to start. He gets committed to stand trial, waiting 10 years for the High Court hearing to start before a jury. If it's a summary offense, it could take 3 years for the matter to start, depending on how diligent the court is. And after we coming out of a COVID period where things were in abeyance for 2 years, you had to join the queue and you were a trial. Now, people who are coming before the court in this current time had to wait to give the men who were sitting in the jail for the last 2 years, or matters that were lying still for 2 years to be ventilated before the court. So you're joining a queue. The purpose of the Plea Bargaining Act is this. While all that is going on, you have a criminal charge lying on your shoulder. And when your employer asks a certificate of good character, you can't get one, because it's showing that you have a gun charge or a sex offense charge, a marijuana charge hanging over your head since 2010. So the man anxious to get it over with. So what he does is the court always say to you that you have the opportunity to plead guilty. And if you plead guilty, the court will not embark on sentencing. So they've introduced what we call MSIs. We have maximum sentence indication. A man could come before the court and say, through his lawyer, if I plead guilty, what are you going to do with me? I'm making a jail or I'm paying a fine? So the court will say, we are obligated to tell you what we could do at its highest point. The worst scenario, they say, you pay a fine. So you say, well, if I pay a fine, I ain't going to jail, I'll plead guilty and pay the fine. It's as simple as that. That's what you call a maximum sentence indication. So you give the man an opportunity to offer a plea of guilty. If it is he's satisfied that the possible sentence is something that he could live with, he could cope with. Most of the time, once a man knows he's making a jail, he'll pay a fine and come out of that. He isn't too bothered by the fact that he has a conviction now. Now, for a man who believes that he's innocent, he's not going to take no MSI. He's not going to listen to no maximum sentence indication, knowing that they're going to be offering worst case scenario a jail term or worst case scenario a fine. He'll be saying, but I'm going to get convicted of an offense that I didn't commit. So he said, I'm going to trial. So that's an option. Now, they always give you the worst scenario. Your defense attorney now will argue that, listen, if the court is offering me a jail term of 2 years, by the time the lawyer done talk and he explain and mitigate and speak well of you, and they provide testimonials of how a wonderful child you were growing up and how God-fearing you are in your current state, and what you just did in terms of the offense you committed was a crime born out of necessity. And they discuss that you plead guilty very early, so you're entitled to a 1/3 discount on the original sentence. So they reward you for pleading guilty early and saving the court's time. So by the time they work out your 1/3 discount, let's say on a 3-year term, they offer you a 1/3, so you're down to 2 years, and then they give you a further discount for good behavior, meaning you don't have a history of criminality. It comes down to maybe they might give you 6 months to a year. The tendency, the court rules, if the court rules along those lines, they give you a 6 months to a year down on a discount for good character, you're down to 1 year. Then they would look at these testimonials and the pastor, the parishioners and the social groups, the civil groups that you work with, give promising testimonials. They say, well, all right, we bring it down to even less than that. We bring it down to 6 months. They have a probation officer's report who said that the man is a reformed individual, and they say glowing things. They talk to his family, they talk to his children, and they might bring it down to 3 months and the man pleads guilty. So maximum sentence indications are like that. Now, the thing with Nelson is this: with plea bargaining arrangements, these arrangements is another offer on the table. It's another way of bringing to premature closure, something that if it goes through the full ambit of the court could tie up for years, remember?
No, but what I'm saying is, I understand that. And I understand the MSI, maximum, no, MCI, maximum
MSI,
case.
maximum sentence indication.
Right. So, right. What I'm saying about that is if that is the situation when you arrange it, first question, when you agree to it in terms of when you get the information as to what the worst case scenario is, and if after you hear that the worst case scenario is that if you lose, you'll get a year sentence, and then they decide, I'm going to the trial and not accepting it, but I believe I'm innocent. Could that change after? The sentence would still be up to what they told you the worst case could be.
Yeah, whatever you discussed in terms of the MSI, if it is you were willing to sign, what they do is the prosecution offers you agreed facts. If you're agreeing that this is the case against you, and if you accept that you're guilty and accept that this case against you is what the police say it is, and you sign the agreed facts, and the court then now looks at the fact that you agree with the case, with the facts, the police scenario against you, and then they offer you a sentence based on that. Whenever you change your mind, if at the end of the day they offer you a jail term or a light jail term and you change your mind, the court is not supposed to allow this mind to be obfuscated or bothered by. They're supposed to operate as if it is, that never took place, and now go to trial. In other words, the considerations that went into the MSI will not offer itself in the trial. You're going to the trial process with clean hands. They're not going to raise anything that any discussions they had concerning your culpability. It sounds like, strange, but the court could do that. It could Clintonize itself. It could divide itself and say, you know what? The man may have wanted to plead guilty. We offered him something to plead guilty. He said he preferred to go to trial, and decided, let me forget that and we're going to trial now. They're not going to raise issues that were discussed in the debate.
But could you offer money as one of the things under this act to get someone to plead guilty or to testify or cooperate? In this case, in a case such as this one, not necessarily this one, does the state possess that option of money of one to support the prosecution of another?
Right. In both the MSI and in their plea bargaining situation, the state can, the individual before the court can offer what we call compensation. So the individual is free to offer compensation and with the offer of compensation, they can even lesser his jail term or lesser his fine, or he may offer the compensation and it forms part of the agreement that he's going to offer compensation and in exchange for complete immunity. So it assists. So the answer is yes. If it is somebody has suffered loss and the loss can be recompensed by way of a financial payment, and he's offering that, then the state can very well accept the offer, and therefore it might inspire the final decision to be that if the loss suffered by the persons involved turns out to have been minimized or neutralized, then no harm is done. The money puts us in a position where the harm has been reversed, and therefore we can offer immunity. So even at plea bargaining levels, where we discussed earlier that we can have a pre-discussion between the prosecution, between the DPPs at state counsel and the man's defense attorney, and he offers compensation in exchange for complete immunity. If it is that has been discussed at that level in the plea discussions, and parties on both sides say, all right, that sounds fair. We won't take the compensation. In exchange, you will offer evidence against the other parties, and you will get complete immunity. Then the individual could say, well, I have no complaint to make. I'm coming out with my reputation intact. I'm offering only a little money which I can afford to pay, compensation. And all I have to do is to offer evidence against the other persons, no problem. That sounds like a deal I could accept. They sign off on that. But remember, you're not dealing with a taxi driver, not that I want to undermine the intelligence of a taxi driver. You're not dealing with a vagrant, a street dweller. You're dealing with an articulate mind and experienced individual, a Queen's Counsel. So he makes sure that part of the arrangements is an indemnity arrangement where my business and the facts surrounding what I'm pleading guilty to here isn't thrown into the public space and isn't made available to foreign authorities, foreign disciplinary bodies, because he has a profession to return to. So when the indemnity arrangement between Mr. Alwari signed in October of 2017 and initial again in 2019 wasn't honored, the terms of the indemnity, meaning to keep certain information in a certain space and not allow it to enter into another dimension. When that was breached, the first thing he did is he sued the state for breaching the indemnity arrangement, because that was a concrete document that was signed by both parties. And the Office of the Attorney General now will have to account for why it is, if indeed, because remember this matter is now before the court, so let's not pass judgment here before one of us gets sued. If indeed the Office of the Attorney General did not honor the terms of the indemnity, if that is a finding made at the civil level, then the state will be ordered to pay damages, and Mr. Nelson will make would benefit. He would be reimbursed for the breach that took place, because he signed a concrete document, a legally binding document, that certain conditions ought to be met when he did what he was supposed to do on the basis of re-entering into this indemnity arrangement, and he offered his guilt, right? He offered the plea of guilty and he accepted culpability. He was supposed to be benefited more than one way, not only immunity from prosecution, but his information and certain data not being offered outside of the courtroom and into the public space. When that was breached, he simply said, well, the next leg of it, which is offering evidence against these two individuals, I'm not doing it because it was conditioned on you honoring certain terms which you didn't, or you allegedly didn't. So that is when Gaspard said, well, if we have to wait until the finding of the civil court as to whether the indemnity arrangement was breached and then proceed, we are literally having an axe hang over these two holders of public office head indefinitely. We don't know when that thing will be completed. And in terms of criminal prosecution.
Therefore, one could argue then that potentially the former AG did no wrong, in terms of part of the discussion in the public domain is that the gentleman was being paid. Because no Pamela Elder asked those things, why you paying him so much money?
Right.
Could that be answered then? Or what you have said is enough to say, well, it takes that into account?
Well, it takes that into account. The arrangement in terms of how did they arrive at that figure is not something that is going to be in the public space. The money that he was ordered that they were paying, we don't know what was the empirical data that went into that calculation. That extrapolation is something that wasn't put in the public space. So when Mrs. Elder, senior counsel, indicates why it is they were paying that much, that is a rhetorical question. Not even she would know.
Right. So why raise it?
Well, it is being raised because it invites the question as to, if it is you're going into an arrangement with an individual who's a witness, right? And he is the person that your case pivots on, the strength of your case. Then you, in entering into that arrangement, must be very, very sure that he will do and honor what ought to be done when the time comes. And if it is, you know, that he has the capacity to withdraw the evidence that he intends to offer at this stage, at any point in time, he can withdraw that, the offer being made. You have to ensure that you box him in such a way that he cannot refuse, and there are consequences to refusal. So in the Attorney General's office, I don't want to say Mr. Alwari, in the Attorney General's office, if that office is the responsible party for not following the terms and conditions of the indemnity, then they knew what it took in order to bind legally Mr. Nelson and therefore force him to offer the evidence or to cause him to do so. In terms of the arrangement, in terms of what money had to be paid by him or what money has to be paid in the reverse, all that would have been part of the discussions, but that would not obviously be form part of the public space, because it was part of the arrangement for that not to be made public. So David, you see where this thing is going.
I'm listening.
Yeah. You see, the responsibility lay with a public office. The office of the Attorney General had a responsibility to ensure that we don't breach the terms. Now, I am not saying that the office breached the terms. That we were dealing with it purely from the point of view of the arrangement was made arising out of plea discussions and the information not being made public. The suit is against a certain office, and the office has to now defend itself as to whether they were responsible for the information being made public. And as a result of that, if it is they were in breach, then it is within his right to withdraw the offer he made. So Richard, it's almost like a circular argument. We can't get into, you see what happened on the plea discussion table? The public will never know. It's only the law makes strict requirements that the prosecution team, the state counsel for the state, out of the DPP's office, they are having a discussion with the defense attorney for Mr. Nelson. Whatever discussions are being held at the plea discussion level, and whatever agreement is being entered, the agreement is being entered, and then it goes before the registrar of the magistrate's court. Or in this case, it would have gone before the registrar of the Supreme Court. It would have been, their plea agreement would have been lodged there. When the registrar of the Supreme Court receives the plea agreement, and this is the registrar of the criminal division, he in turn will then make it available to the next channel. The judge isn't involved in the arrangement. The judge looks at the facts and says, all right, an individual is willing to plead guilty, and they have gotten to the point where there's a plea agreement. The plea agreement, the stage that he is at is he receives the agreement before him, and he looks at what the arrangements were. And when he looks at the arrangement, when the judge looks at the plea agreement signed and lodged with the registrar of the criminal registry, he would now make a determination based on what is before him. If the DPP's office, state counsel, and the defense attorney have had discussions and they've come to certain conclusions, the judge is guided by what that agreement says. Mind you, a judge could very well say that I'm not in agreement with what happens here. And I think that this man is being treated in too much of a light-hearted manner. That in the interest of justice, I am not in agreement with that. And the judge he can simply set that aside and then proceed to sentence in a way that he thinks fit. So the judge is not a rubber stamp. He just gets an indication from the plea discussions and the agreement signed by state counsel and defense attorney, as this is where our heart lies. He could simply, at that point, set that agreement aside and proceed in a certain way to sentence custodially, or he could simply be guided by that document. In this case, the judge was guided by the document. It is very unlikely at times for a judge to go against what the plea agreement reflects. But he has the power to do it. His hands are not tied.
So sum it up for us, Farid, if you could. Technically, you're saying, therefore, I know you can't predetermine, but there's no there then, based on what has happened.
There is no
there, nothing really, per se.
Right. The position is this. It is what it is. The charges has been withdrawn. What can happen in the future is the charges can be relayed, but deep consideration has to be given to abuse of process applications being made by the defense and applications being made along of the lines of there has been enough bad publicity and pre-trial publicity surrounding the facts of this matter that to relay the charges of abuse of process, and it will not, and we can't get a fair result. But we've had discussions like this with other parties in this country. Yassin Abu Bakr once made an application before one of his trial processes where he said because of the stigma attached to his name, he could never get a fair hearing and be treated in a fair-minded way by a jury in this country because his name has been associated with everything nefarious and everything wrong and everything unjust. And therefore, he was saying to embark on a trial with him is an abuse of process, and we could never get fair results. That was not the only individual in our history that raised that argument. When Dolcedi went before the court in the early 2000s, before his trial, I believe it was 2003, his argument simply was that it's impossible to convene a jury of his peers in this country who hasn't been affected and impacted by the negative press and publicity and media play that is given to his name on a day-to-day basis for things that he didn't even commit. It became a social media trend, if we were to put it even back in those times, or a trend, a cultural expression to associate nefarious and criminal with the name Dolcedi. But you know what? When that argument was raised about the inability to convene a jury of one's peers and having a fair trial, at his trial, the ruling of the court was simply, there are mechanisms that could be put in place. If it is you don't get a fair trial and you're convicted at the high court level, you can go to the Court of Appeal and appeal the decision. You can and raise the grounds of you didn't get a fair trial there. If the Court of Appeal is not in agreement and they uphold the conviction of the High Court, you can go to the Privy Council. So that is what was said in response to that application, that yes, you may be of the view that you can't get a fair trial, but the justice system of such that there are appeals. There's no decision is final. You have two appeals.
You heard what the opposition leader had to say?
Well, let me hear you in terms of her response.
No. Daddy Mac, you have the clip from the opposition leader?
No, I don't have the clip from the opposition leader.
No, I was wondering if you heard it to see if you could have cleared it, because from the little I heard, it sounds as though she too is saying there's some there. There's something more.
Mm-hmm. Yes, I agree with that. From what I saw in the newspaper, she's saying that.
But you see, the thing is, at the end of the day, when this thing hits the ground and the dust settles, the position would be that the public is not in a better position to adjudicate on this matter than the courts, and the public must accept what is in the public space. Whatever the perceptions are, whatever the innuendos are with regard to whether this situation, however it came to an end, Mr. Ramlin and Mr. Ramlogan, there has been no evidence offered by the state to bring into disrepute their character vis-a-vis or pursuant to these allegations of conspiring to defraud the state, and no information as to they conspiring in any way with regard to money laundering, corruption, and misbehavior in public office.
Even though Mr. Nelson said he's going to testify against them?
And he didn't. even though Mr. Nelson says that he is going to offer evidence, the information that is before a court is not information that has been verified and tested under the ambit of cross-examination. In other words, when it is evidence is not, as a former senior counsel used to say, evidence is not a piece of paper blowing in Woodford Square. Senior counsel Frank Solomon said that in the off inquiry into the Judicat. He said that piece of paper that's blowing in Woodford Square that people claim is evidence has to be brought before the court, and it has to meet certain standards and before it could be admitted into evidence. And if it is that whatever is being offered by way of the statement of Mr. Nelson is to be treated as credible evidence and is to be treated as strong evidence and evidence that meets a certain standard, which is, in this case, it would have been not beyond reasonable doubt on a balance of probabilities, a lesser standard, or albeit a standard. That evidence that Nelson has to offer still has to be subject to the verification and the cross-examination by defense counsel. So if it is the evidence was never offered, although Mr. Nelson is saying there was a conspiracy, if that is what he was saying, then until he offers that evidence in the courtroom and defense counsel is cross-examined by and state witnesses is cross-examined by defense counsel Pamela Eller, Mrs. Eller would not have gotten the opportunity to undermine the credibility of Mr. Nelson and to shake his credibility by way of probing questions and to undermine the veracity of what he's saying and to test the quality of his evidence. When it is that has not been done, then the justice system has not exercised its will on the witness. So the witness has to subject himself to cross-examination, and based on his demeanor under cross-examination, credibility will be assigned to what he has to say. So it's almost as if you corner a thief and he has items in his hands that belong to you. Yes, it may appear that the man is a thief, but he only could be convicted and sentenced after what that exhibit that you found in his possession has been seized and brought before the court and laid before the court and accepted as evidence of that which you found him with. And then he be cross-examined or evidence be offered with regard to proving a case against him, and his defense attorney cross-examine you. What if it is the man say, well, the definition of theft is for dishonestly appropriating property belonging to somebody else with an intention to permanently deprive. And he's saying to you, I agree that the lawnmower that was in my hand, the cutlass that was in my hand, the money that was in my hand may have belonged to you. But that in itself doesn't prove that I'm a thief. You must prove that my intention when I had it in my possession was to permanently deprive you. I was simply examining it with a view to returning it to you. So unless you could prove the other limb, which is my intention when I took possession of it is to make sure that you don't get it back, and I intend to dishonestly appropriate it with a view not to giving it back to you, then we haven't established theft. So in the same manner, when it is we look at the facts, but
if it is somebody whom you would not normally lend your lawnmower, your cutlass to, and they take it, the logical conclusion would be that they appropriated it, because you would not have lent it to them even if they had asked. So how they got it within their possession?
Right, but you still
just like you use that same definition, which is appropriating property belonging to someone else with the intention of permanently depriving them of it.
Right.
If you go to a supermarket, as they say when I was doing law, they always use that, and you decide to take up a chocolate bar or something, and then for some reason you put it in your pocket, and then for some reason you apprehended fear and rest it back on the shelf. The act of theft occurred, although you put it back. So if you apply that,
no, Richard, I want to defer on that. I want to if it is you put the chocolate bar in your pocket and you walk past the cashier and you haven't exited the door and the security put their hands on you, right? You would have appropriated property belonging to the supermarket. You would have acted in relation to property belonging to another in a particular way where you took it into your possession. There's no doubt about that it's in your pocket. you haven't exited the building as yet. You're still within the confines of the building. You haven't exited the door and you're held. If it is at that point you say that you did not intend to permanently deprive, that you mistakenly walked out with it, they must prove the next step that you intended to permanently deprive. You haven't intended to permanently deprive until you have left the compound. That is why it is the security normally holds you in the car park and say, well, you left the building with it. So people who take things, and you must be, as the prosecution and the police must prove the limb of intention to permanently deprive. I agree with you that when you took it up in your possession, you took your appropriated property belonging to somebody else. But the intention to permanently deprive, that element is only established when it is you could prove that you exit the compound, you left the confines of the person's premises with it. So then,
no, I'll tell you, and in law they always have debates over these types of things. I ain't going to debate it now. I engaged in some of them in the past.
Yeah.
The convergence of the intention and the act that may have constituted theft occurred at the time when you place the chocolate on your person and not in the basket that is provided by the supermarket. For any person who wanted such a chocolate or anything, you put it in that basket. That's what the owners of the supermarket provide customers with. You place your goods in that basket and you carry it to the counter and you pay and you leave. When you decided to put it in your pocket, you had the intention at that moment. It is at the convergence of that point is where the act of theft took place, because you intended to permanently deprive. But what happened is that for some reason you believe you'd have been caught or something. This is why I said you apprehended fear and you put it back down. So you rest it back down because you believe you'd have been caught, but you had already committed the offense.
You have a window.
I have cases like that, from London University. That's the point from which they take it.
The thing with it, David, and Richard, if it's that intention to permanently deprive, you have a window period in which to change your mind. Up until you
no, but the argument there, since I had so much of it, would have been putting it in your pocket, because as a reasonable man, and this is not somebody talking about who suffers with diminished responsibilities or something like that. No mental abnormalities. You put it in your pocket, and you knew at the time you were doing that is not where you're supposed to put it, and you knew also that you were putting it there because you wanted to take it without having to pay for it from the supermarket. But then you believe that you discover a camera in here, or you believe a security guard saw you, or you see a security guard watching your direction and then took up a position by the door waiting for you. And that caused you to rest it back on the shelf. You may have committed the offense. That is the arguments we had at the time, at that stage of theft. And I don't think at that time the word attempted was introduced there.
Listen to me. Farid said the supermarket will provide these baskets and trolleys for you to put these items in. So it is a case where the guy who took up this chocolate had a basket in his hand or a trolley and still put it in his pocket. Well, then that has to be theft.
That is theft from London perspective. University. That is theft.
Allow me to say this.
And then on stealing of Farid, you can't steal something and then unsteal the same item. You committed. You have to look at the stage. You committed the offense.
Have you ever been to the supermarket and you take up a pack of nuts and start to eat it while you're shopping, and then when you reach you declare the packet and say you're going to pay for this or eat this?
No, that is permissible. Hear how that is permissible. I do that especially during Christmas time when I go with the family to the supermarket because of the numbers of people in there and so on. But here what you have to do, while you're consuming it, or when you finish consuming it, if it's a drink, you rest the bottle or the box in the trolley and you pass it and pay for it, although it's empty. But you consume the content already. You didn't put it in your pocket. You take the pack and you empty the nuts in your mouth and then you consume it. But then you put the pack in the trolley. That's acceptable. They do that. Yeah.
The intention to permanently deprive. The intention.
Remember, it is only what you say. It is only an intention to analyze it. It is an intention to permanently deprive. So when you put it in your pocket, you had the intention to permanently deprive the supermarket of it, but then something happened that caused you to believe you're going to be caught, and you change your mind.
If
but
you're on the compound,
if
you're on the compound and you haven't exited, and you may have had the intention when you pick it up to permanently deprive, but you decided, you know what, let me pay for this thing. You haven't left the compound yet, so you still
they could still hold you because
they could hold you, but they can't convict you. You could still say,
see, you specialize in defense, right? So that you would have an inbuilt wall out for defense. I understand that. You are a superstar defense attorney, so you want to see how you can defend this. And going with what the law states. You will come up with the defense arguments. You know? And that's okay. And that's acceptable because if I was in your position and I had to defend it, that could be my argument too. At what stage permanently deprived kicks in? You saying when he did it, he had that, but he didn't leave your building. He's still in your premises. And you'll argue that down to the wire.
The only person who could prove the intention to permanently deprive, right? Or prove that he was in a position where he wanted to permanently deprive is the security that arrested him based on the fact that he exited the compound. From the time the man is within the walls of the compound, even if it was his intent when he took it up, is to slip out the front door with it. If it is, he figured when he reached the cashier or he's walking past the cashier with it in his pocket that these people, somebody, the security watching me from there, looking like they have a sting operation by that door, he could turn and say, hey, look, I forget to pay for this, you know.
Why have it in his pocket if he has a basket?
But the fact that he have it in his pocket just means to show that, you know, he just inadvertently without thinking put it in that spot. It doesn't mean
although he has a basket or a trolley.
Yeah, Farid.
Inadvertently, you know, sometimes absent-mindedness, you put it in the wrong spot.
Farid, to deprive, hear this, to deprive can be distinguished easily from having deprived. It is an intention to deprive, which means you didn't have to actually deprive the person of it, you know, the supermarket. Is that your intention was to do that. By putting it in your pocket, you intended to carry that out to deprive the supermarket. But then you believe you're going to be caught and you change your mind. That's why English London says it is at that point of convergence, right there, where the actus reus and mens rea meet, and that constitutes theft. Because if you put it in your pocket, remember, go to the definition again. It is to intentionally
appropriating property belonging to somebody with the intention to permanently deprive.
Stay right there. With the
can't prove the intention.
No, hold on. Of course, hear this. But you have to look at the future, the use of future. Just like when we talk about to be, sometimes we talk about the transitive verb. Listen, watch this. English. It is the intention to deprive, which means it is an intention to do something that will happen in the future. It is not something that has happened in the past. So they didn't say it is the intention to have deprived somebody. No, it is the intention to do so.
But
when you put it in your pocket, you intended. Yes, by putting it in your pocket. If you had left with hold it, put it in your pocket. Was to conceal it from the cashier. No, hold on. Remember I said we're not dealing with somebody who had mental challenges. Absent-minded in such a situation will be normally flow from someone who has some sort of mental disorder. You are a reasonable man. You wouldn't suffer with that, Farid. Neither David McIntyre nor myself. If I pick up a chocolate in the store, let me tell you, I can be very sleepy. I'll be on automatic to put that in the basket or leave it on the shelf. I can't see me making a mistake and slipping it into my back pocket or inside of these kind of jackets that I wear or in a shirt. Once I do that, I know I just committed an offense. You
could take public transport and absent-mindedly walk out a maxi without paying. because your mind on your ultimate journey. And is the conductor remind you, whoops, you're supposed to pay. You didn't leave there with no intention.
Hold on. Fareed. That one is different. That one is more acceptable. But you absent-minded cannot really cover in an umbrella fashion somebody picking up a chocolate or a whole chicken and trying to fit it in the jacket or under the skirt and putting it into some kind of net they have underneath or whatever else holding up them thing. Because I saw a video with people putting half a store on the skin and walking out normal. So that is different, Fareed. Some of those people were held. They didn't leave the store and they were convicted of theft. But all the goods stay in the store. People in this country have been held for putting chocolate in their pocket. No,
they should not represent themselves. That's why they say you must represent yourself in a
Yeah, I agree. So they committed the act and then they had poor legal representation, which flowed from themselves. I understand that. But the fact of the matter is they would have been convicted for the same theft. Yeah. Notwithstanding, the organization would have gotten back the property right away. So, in other words, you are really leaning on the good quality defense that you have been trained to apply to your clients. I'm not talking about that side. I talking about the naked law and where the offense has been established. The offense of theft is established at the point when you put the item that you took off the shelf somewhere onto your person other than the basket or trolley.
Let me give you a nice example, right? Mm-hmm. Many years ago, about when I was in practice for about a year, a guy came to me. We had a conversation. He was charged before the court for thieving a bottle of scotch out of a very popular supermarket in this country. So let me try to make it as nebulous as possible. And I said, boy, you sell your reputation for a bottle of scotch. He said, to be honest with you, that was about the 17th bottle of scotch I stole for the day. He said his whole day I was doing that. I get catch on the 17th bottle. I said, 17 bottle of scotch? He said, yeah. So his thing was he was putting the bottle of scotch under a big jersey. It wasn't metro style jerseys in those days. It wasn't, when people was wearing some big baggy jerseys.
Big clothes, yeah.
So he was putting it under the jersey, under his belt. That was holding his pants up, so it's wedged there under his belt, and he just casually keep walking out. And when people realize, but this man shopping all day and leaving with nothing, they decided to give him a rub down.
No, he was shopping. He was shopping, and on all the occasions, not in the way the store intended for him to do it, but he was shopping.
They find the bottle of scotch under his waistband, and he got hold for that, and his thing is, well, he clearly made up his mind that he was going to appropriate property belonging to somebody else with the intentions of permanently deprive, and he was caught when he exited the ambit of the supermarket with the thing in the car park. At that point there, he was brought before the nearby police station and questioned about it. They tell him we get you with the bottle of scotch red-handed on your person, and he said, well, I'm sorry about that. Of course, he didn't tell them about the 16 bottles before. And nor was there any CCTV footage camera that picked him up. It was just a sharp eye of a security guard of a man keep entering and leaving. So,
Fareed, a person could be declared, how do you call him, one who burgles a home or a building, a burglar. I think that's however you call him.
Yeah.
But someone could be declared to be that way if you form the intention to go in a legally open business, but you form that intention outside of the business before you enter, that you're going to steal inside.
Well, I would consider him not a burglar. I would consider him a would-be burglar. He would be a burglar if it was caught.
No, you see. No, that you go into your job, Fareed. That's what you do. I'm dealing with the law, Fareed. Of course, if these things don't happen, how defense attorneys go make a living? Come on. So you had to argue that. We understand that, and you might argue a lot and you'll be successful 9 out of 10 times. But I'm saying, Nonetheless, in the law, you are declared to be such a person even before you enter the supermarket. Once it can be proven you had formed that intention before you enter. How is that? Because the owners of the supermarket did not consent to you coming into their place with the intention to steal. They open the door when they say they open to allow people who have intention to do business with them legally to enter. In other words, their door when they open it, when they put open on the sign, that sign open is only for people who come in to conduct legitimate business. If you form an intention to go in there to do something other than legitimate business, you are an intruder, in other words, in local terms, from the time you go through that door. And all that is left to be done is for them to be able to prove it after. And often they do. When you go in there and you inevitably produce the outcome you went in there for, then they will know, and in tracing, they may discover that you had spoken to somebody else before you went in. Because, depending, if you entered with a clear mind and having been in there, realize there's an opportunity to steal, and then you decide to put something in your pocket, then that is a lesser charge. You know that?
Yeah.
But if you enter the supermarket knowing that you're going through that door to steal, that's why I think they say being a burglar is a greater sentence to one who's just a thief. Because it's two different mental applications that would have been taken into consideration, and the perpetrator would have been one on one hand who had formed the intention to do wrong before he entered, which is worse than a perpetrator who didn't enter as a trespasser. I think that's the term I was looking for. You are a trespasser from the time you enter a business place with the intention to do wrong. You're a trespasser. Because when they put that sign open, they put it there only for non-trespassers to come and do business with them, which would be legal persons who come in to conduct legal transactions with the organization. And if you form the intention after you enter and you are caught, the crime there could be less than if you had formed the intention to do so before you enter, and therefore you entered as a trespasser, the charge could be more severe.
When it is you arrested, David and Richard, that is the purpose of the police investigator, to determine what was in your heart. When it is he starts questioning you, in the interview process, he could trick you or cause you to give an indication as to what your intention was. If it is that's why it's important to exercise your right to silence and leave the police with the strict responsibility to find the evidence somewhere else. The worst evidence against a man, but the best evidence to convict a man is his own words. So that's why they often say exercise your right to silence and leave the responsibility on the police to prove the case against you. When it is you confess, the hardest job a defense attorney can have to face is a confession. So most times they tell you... It's
hard to walk that back.
Yeah, most of the time they tell you, exercise your right to silence and let the police, let the cards lie where they may. You give the defense attorney more elbow room in a courtroom when it is he doesn't have to argue with his client's own words. So the intent, to prove that intent to permanently deprive, the police had to come up with something substantial. They have to come up with things that, we had him under observation, he placed it in his pocket. He walked through the normal channels of passing the cash register. He paid for some items and he exited with certain items under his t-shirt and under his waistband. And then when they're able to offer that now, they could say he entered the car park, he entered the public space. So he did intend to permanently deprive evidentially because he didn't declare the item and he exited with it. So the inference could be made having exited the compound with the item, not declaring it and knowing it was being offered for sale, that he intended to permanently deprive. The defense attorney may want to say, as long as he's in the building, he's quite capable of declaring that he intended to pay for it, but for whatever reason, he didn't do it at the cash register. But he has a gray area, a window of opportunity once he remains on the compound to pay.
Farid, I want to thank you for your explanations today on these critical matters. I also want to thank management for the reminding queue. Such fantastic people and wonderful decency, if you know what I mean. So I just want to give the last word for Reed. We have about 1 minute and 23 seconds from what my computer said in the corner to 6 o'clock. I'll give you it. Yeah.
To the listening public, don't go out there and deprive people permanently of their belongings. Don't appropriate property belonging to somebody else. Do the correct thing. And when it is your shopping, declare the items that you have. Keep it in the basket provided. Otherwise, you're going to have to pay the Defense Council an excessive amount of money to retain your good name.
It would be a lot more than what it would have cost you to pay for it the proper way in the beginning.
That's right.
Yeah. All right, Farid, take it easy, and Daddy Mac get home safely. Farid, next week, nice show. Thanks for the legal information.
Yes.
We understand it better now than we did when we came on. Thanks again.
Yes, thank you so very much.
Blessings.
Yes, man.
Yeah.
That's it for